This is LXBN TV, and I'm Colin O'Keefe. The case of Savannah Dietrich is one of the more interesting First Amendment cases to come along in some time, and as could be expected in today's modern world, social media plays an important role. To explain the case, we bring in Maryanne Stanganelli, attorney with Baker Hostetler in New York and author on their blog, Media Law Bites and Pieces. Maryanne, for those who don't know the story already, can you give us some background on who Savannah Dietrich is and exactly what happened?
Sure, Colin. She's a sexual assault victim in Kentucky, in Louisville, Kentucky. She's 17 years old, and she claims she was sexually assaulted by two boys, who are also minors, who then proceeded to videotape the incident and circulate it. She brought the case to the attention of the police, who arrested the two defendants, and the entire juvenile court proceedings have now been confidential under the Kentucky rules. At a June 26th hearing, Savannah Dietrich heard that there had been a plea bargain. She was not happy with the plea bargain against the two defendants, and the judge in the case, Judge D. McDonald, reportedly, and this is everything that we know about the case is from Savannah Dietrich, since there is this confidentiality in place. But according to her, the judge issued a blanket restriction on talking about not only what had happened in court, but the underlying facts of the case in general. Savannah was already unhappy with the plea bargain, now unhappy with the fact that she is not allowed to talk about it. She went to Twitter and revealed the names of the defendants. She sparked pretty much an internet sensation. She'd been reported in blogs. She's told her story to the Courier Journal, which broke the story. They did not report the names of the defendants. And there was even a Change.org petition started by a woman who didn't even know Savannah Dietrich, and they got over 50,000 petitions in one day to try to overrule the fact that she was now subject to contempt of court for violating this order from the judge.
And of course, this is such an interesting and unique circumstance, with it being juveniles involved, but, is the gag order in this case constitutional, or does it violate the First Amendment?
Well, interestingly enough, the judge who issued the order has now come out and said that she doesn't see it as a gag order. She was just following the laws of Kentucky and doing what she can. But nonetheless, I think if this were actually to go through, it would be a very hard case to say that it is constitutional. This is accurate information that Savannah Dietrich had in her own. I mean, she's the victim. She obviously didn't get this information from the court. She had it from her own experience, and that's what separates it from a lot of cases where newspapers are involved. And the question a lot of times becomes, how did they acquire the information? Was it legally obtained? Here, there's no question that it was. So it would make it a really hard case to say that the order, as stated by Savannah Dietrich, as what Judge McDonald said, was constitutional.
Yeah, exactly, because I had read that, you're not allowed to share the proceedings of the court, but she wasn't necessarily sharing the proceedings of the court. She was just saying, what exactly happened based on, same thing could have come out had she been in the court or not.
Right. I mean, it's an interesting case. The defendant's attorney was the one who originally filed the motion for contempt, obviously cited the privacy rights of their clients. And in general, these kinds of confidentiality in juvenile court proceedings are there to kind of protect, young criminal offenders so that they aren't scarred for, marked for life. But in this case, I don't understand the privacy rights that they're trying to protect, since they had posted this information publicly themselves, so their expectation for a right of privacy is kind of interesting in this case. I think that is another factor in this case that would kind of weigh in favor of the First Amendment rights of the victim.
Definitely, and some people have used this case to paint a larger picture, providing a commentary on the state of the First Amendment right now. But what do you think about this case? Does it say anything about the First Amendment when this type of free speech is silenced? And you see things like the Westboro Baptist Church, and then even just a recent Supreme Court case where people can lie about obtaining military medals. I mean, do you think there's something more there, commentating on the state of the First Amendment, or do you think this just is a case on its own?
Well, I think in this situation where Kentucky is one of a very few states that have such strict confidentiality of their juvenile court proceedings. And were Savannah Dietrich to challenge the order and go up the legal channels, it's highly likely that she would end up exactly in the same position. What's more interesting is the fact that she did it her way. She didn't have to pay for legal costs, and she made it extremely public. She made the defendants way more well-known than they ever would have been. So I think her cause was served, but more so by going this route, which is not exactly the accepted route. Mm-hmm. Typically, if you're going to challenge something as unconstitutional, you're going to want to go through the accepted channels. So I think this case is an easier one because of that. I think the Westboro Baptist Church really challenges core First Amendment advocates because what they say is so reprehensible and the place that they do it is so reprehensible. Mm-hmm. I think if there ever were a case to expand the limitations on First Amendment, it would be in a situation like that, where it's essentially can be argued as hate speech, or maybe you want to expand your fighting words doctrine into that. I think that's an area that's actually way more difficult to argue First Amendment.
Mm-hmm, definitely, and that's what's so interesting about this case. Was that point you just made is that she chose not to fight for her rights under the First Amendment. She chose to take it into her own hands because the technological tools that are at everyone's disposal nowadays enable you to do such a thing. And from now on, whenever anyone Googles these two defendants' names, they will be permanently on the internet for all time to come. And this ends up being more powerful than anything she could have done through the legal process. So that's what's so
exactly. I think that's an extremely interesting aspect of this case for both the outcome for Savannah and for the defendants.
Mm-hmm. Absolutely. Well, once again, that was Maryanne Stanganelli of Baker Hostetler and the firm's blog, Media Law Bites and Pieces. This is one of Baker Hostetler's newer publications. It's definitely off to an excellent start, so be sure to visit that. It's at MediaLawBitesAndPieces.com. And for more of our LXBN TV interviews, visit us at lxbn.lexblog.com. Thanks, Maryanne.
Thank you, Colin.